Good morning, everyone, and thank you for joining us for our 9th annual CPD Bootcamp. My name is Carl Schober. I'm a senior associate in our privacy, marketing, and transform technologies group. I'd like to begin by welcoming all of our guests and our speakers who are here at our Dentons Toronto office. Thanks so much for your time, commitment in joining us, and of course, a warm welcome to those of you who are on webcast. We look forward to your participation throughout the day. Contribution. That's a good start. Contributions today. For those of you who are attending in person today, we also want to remind you that we have a sign-up sheet that you should be signing between sessions, between each next seminar. To make sure you are in the, just make sure you're in the correct session. The first session here is a presentation on critical issues and developments in data. I'm not saying pre-trial injunctive relief is not fascinating, but I think you made the right choice in joining us on this session. But the other one is one floor below us, in case that's where you thought you should be. Presenting with me are my colleagues, Chloe Snyder, a partner in our litigation and transform technologies group, as well as Luca Lucarini, our new associates in our privacy and transform technologies group. We have a lot of stuff to cover in this session. We'll try and reserve some time for questions at the end. And also just to remind you that you will be getting a copy of the slide deck after today. So no need to furiously write notes because some of these slides are a little word heavy. So I'll start with, there we go, Luca.
Hi everyone, so just to outline what I'm going to be speaking to today. First, I'm going to talk about Canada's Digital Charter and what it may mean moving forward. Then I'm going to give a recap of the one-year anniversary of mandatory breach notification in Canada and what that might mean. And then I'm going to spend a little bit of time on some best practices respecting breach notification. So just to take the temperature, is everyone familiar with the Digital Charter? Do people know it exists? So it was introduced in May of 2019. And essentially what it is a set of non-binding guidance, a set of principles that articulate the federal government's approach to data strategy moving forward. So it hasn't made law as such, but it does signal the development of the law moving forward. And again, I would stress that this is all non-binding at the moment. So it's organized around 10 principles, and I'm just going to highlight a couple of them that are most relevant for today's presentation. So the first is number 3, control and consent. Essentially, what this is dealing with is changes to PIPEDA that essentially tip the balance towards the consumer and away from organizations. Number 4, transparency, portability, and interoperability. So this is essentially a statement of consumer data rights. There's a sense that consumers don't have enough control over their data currently in the digital economy, and so there's a move towards creating rights. And just a couple of these terms, when we're talking about portability, that's a technical term which means the ability for platforms to talk to each other and for services to interact. So if I am a telco subscriber and I want to move to another one, it's essentially talking about embedding a consumer data right that would allow me to seamlessly move my data from one telco to the other and having the interfaces speak to each other. Number 6, a level playing field. This is essentially a statement of the Competition Bureau's increasing engagement in the digital economy. So in February of 2018, the Competition Bureau concluded a year-long consultation process and came out with a paper that basically stated that, in its opinion, its existing tools under its enabling legislation are sufficient to deal with competition issues in the digital economy. And we read that as a signal that it intends to do so moving forward. And I'm going to touch on that a bit later on. And finally, number 10, strong enforcement and real accountability. This is essentially a statement that relates to PIPEDA modernization and the recognition that we have an enforcement model in Canada that is a bit limited in terms of what the commissioner is able to do in terms of its investigations and the enforcement of PIPEDA. So again, I'm going to touch on that a bit later on. So again, this currently exists at the level of principle, and what are the next steps? So the next steps are essentially legislative changes, and the first one that we anticipate happening is modernization of PIPEDA. So I'm going to spend a little bit of time talking about changes that we anticipate will be happening to PIPEDA. So in May of 2019, the government released a discussion paper, and it essentially floated a number of proposals to modernize PIPEDA. So I'm just going to spend a little bit of time going through a couple of these. And in particular, I'm going to look at items 1 and 3, enhancing individuals' control and enhancing enforcement. So I'll just spend a bit of time on these. And again, these are proposals in a discussion paper. These aren't law yet, but they might end up as law. So the first is essentially that they're floating the idea of introducing plain language, standardized plain language into agreements relating to the use of personal information. And this is kind of flowing from a general sense that we have a consent-based model here in Canada. Users give their consent for the collection, disclosure, and use of personal information. And as anyone who's read terms of service, it's they can be a bit not the most consumer-friendly documents. So they're floating the idea of introducing a kind of standard form for that. They're floating the idea of introducing alternative grounds to consent. So as we know, PIPEDA is entirely consent-based with a few narrow exceptions. But they're talking about introducing alternative grounds, which would be essentially mimicking the GDPR's legitimate interest basis for processing personal information. And so essentially GDPR provides that you don't need consent in every case. And that is typically carved out for kind of routine business uses. So this could be a potentially helpful amendment. Introducing the right to data mobility, I kind of touched on that. Adding a definition of de-identified information. So as we know, personal information is defined in PIPEDA, but de-identified information is not. So we know we have a sense of what personal information is, but we have to kind of assume that anything that's not personal information might be de-identified information. So they're floating the idea of actually adding a statutory definition of that and providing a set of use disclosure provisions associated with that type of information. And finally, we're talking about the right to request deletion of personal information. So right now, individuals' rights over in PIPEDA are for under control, under access and correction of personal information, but not deletion. There's no direct right of deletion, so that's being considered to be a bit of an oversight, and so they're talking about introducing a right of deletion for someone who's holding an individual's personal information.
I think that's an interesting point on the last slide. Oh.
Yeah.
I think that's an interesting point on the last slide, though, distinguishing between deletion of information and the right to be forgotten and how they're different.
Mm-hmm. So the right to be forgotten would be essentially, providing for de-indexing. So this exists under GDPR. You can make a request to have yourself removed from search engines. That is not currently what they're talking about. That's a distinction, which is, like Chloe said, deletion of information being held by an organization. So enhancing enforcement. So essentially, this is flowing from the idea that the Privacy Commissioner is conceived of as an ombudsman model. So individuals make complaints. The Privacy Commissioner is then empowered to conduct an investigation. And at the end of an investigation, if it's well-founded, the Privacy Commissioner issues a public report and set of recommendations for the organization. In terms of the kind of core element of PIPEDA, which is in terms of dealing with complaints about people's privacy, that's the extent of the Commissioner's powers. So, in light of changes in technology, they're floating the idea that the Commissioner should maybe have some additional powers. So they're talking about order-making powers in the form of cessation and record preservation, and also extending, essentially empowering the Commissioner to issue fines. And in terms of timing for all of this, there's just been an election. In our view, this is not a partisan issue, so we anticipate that there will be movement on it moving forward. And so we anticipate that there will be a consultation period, but that has not been announced yet. So like I said before, the Competition Bureau issued a paper last year where it basically said that its existing tools are sufficient to address uncompetitive conduct in the digital economy. So earlier this year, in September, the Competition Bureau issued what it's calling a call-out to, quote, seek information from market participants about conduct in the digital economy that may be harmful to competition. And its rationale for doing this is essentially it wants information so that it can, A, investigate, conduct investigations on that conduct. It wants to inform how the Competition Bureau analyzes anti-competitive strategies, and it also wants to inform guidance moving forward. And essentially the question that the Competition Bureau is addressing here is, have certain core digital markets become concentrated to the detriment of consumers and businesses? And you can review the slides afterwards for the two core areas they're looking at. They're essentially looking at tipping and anti-competitive conduct. So that's what we know currently from the Competition Bureau. We don't have any updates yet, but you're going to want to be aware that essentially the Competition Bureau is soliciting information about what market participants may view as anti-competitive conduct, including conduct about competitors. So I'm just going to spend a bit of time updating you all on some numbers that have come in from the Privacy Commissioner in regards to mandatory breach reporting. So as we know, we've now had for a year a mandatory breach reporting regime under PIPEDA. So that means that organizations are obligated to A, report breaches to the Commissioner, and B, notify affected individuals. So it's been in place for a year now, and we have the Privacy Commission has just put out some numbers. So you can see them up on the screen now. Unsurprisingly, the introduction of a mandatory breach reporting regime has significantly increased the number of reports received and the number of notifications sent out. We've heard that in the Commissioner's view, organizations are over-reporting, which has resulted in about a 2-month backlog in responding to organizations. And about a quarter of reports received by the Commissioner don't meet the threshold test for the real risk of significant harm. And just a couple of more qualitative points. The Commissioner is seeing that a quarter of all incidents involve social engineering hacks like phishing and impersonation. And you can, in the slides, we provided a link to the Commissioner's website, so you can dive into it in more detail if you wish. So now I'm just going to spend a little bit of time talking about, on the topic of breach reporting and notification, some of the best practices that we've identified. And my colleague Chloe is going to talk about the context for this in more detail. But essentially what we're talking about here is the fact that now that you are obligated to report a breach, there's a risk that essentially what you give to the commissioner and what you send to customers may form the part of the evidentiary record in a class action lawsuit.
You say may, but I think the word is will.
Yes, you're right. Will is definitely the right word. So essentially, we're giving, these are a few tips that essentially take the frame that when you're sending these notifications out and you're informing the commissioner, this is essentially a form of advocacy. You're advocating before the inevitable class action descends upon you. So the first one is to be direct. And there's a lot of text here on this slide, but the kind of key point here that we want to look at is being very careful about disclosing whether the breach was an inside job, whether it was caused by an employee or someone else inside your organization. And Chloe will talk about this in more detail, but there's increasingly jeopardy based on cause of action based on vicarious liability. So you want to be circumspect about giving that out unnecessarily, that kind of information. The second is you want to be certain about the types of information affected. So again, two things here. The first is not to commit yourself to data elements that weren't actually part of the breach. That goes without saying, but you don't want to expand the scope of what was captured by that was captured by the breach unnecessarily, because that obviously is exposing you to jeopardy. And this is an opportunity for you to say, well, it wasn't affected, right? You can kind of carve out things that you know weren't affected and kind of get those out of the mix. And the third one here is that the number you choose will be the number you live with forever. So, essentially, if you're talking about plaintiff's counsel, they're going to basically do some math to estimate the size of the breach, the potential damages, and that will ultimately end up in the pleadings if in any class action lawsuits. So now, under PIPEDA, you're obligated to report the numbers to the commissioner, but not to individuals in the notification. Now, this is a tip that's based on the risk tolerance of your organization, but you have to kind of weigh. You really want to weigh the kind of two threats, right? So on one hand, you're committing to a number that could potentially, again, form the evidentiary basis for a class action lawsuit. On the other hand, you have the privacy commissioner kind of being cross with you for not giving exact numbers. So you may want to consider which is a riskier proposition for your business.
As Luca foreshadowed, I think really a lot of the best practices for breach notification tie into the privacy class action risk that follows a breach, because as Luca said, whatever it is that you say in your notice to those who you believe were affected, whatever you say to the privacy commissioner, whatever you say in your press release is very likely to be relied upon by plaintiff's counsel in forming their claim and in putting evidence before the court on certification and ultimately in dealing with the merits. And so the words that are chosen for the purpose of the notification are very important, whether you're using the word may have been affected. A word I like less would be likely affected, because obviously the standard of proof is more likely than not on the balance of probabilities. And so unless you are sure that someone was likely affected, to me that would be not a great word selection. As well as figuring out who has been affected and trying to being sure about that number, being that 200% sure about what you're saying in your notification. And why is that? That's because we've seen a proliferation of privacy class actions following really any breach that's been publicly announced, even where, at least from a defense counsel's view, the breach seems innocuous. For example, it involves only contact information. So there was a case decided earlier this year called Brutzes and Rouge Valley, and in that case, the personal information was contact information only. And yet there was still a class action started. Now that case wasn't certified, but it shows the, I guess, eagerness of plaintiffs' counsel to start these class actions. And in my view, there are really two reasons why there's been a proliferation, why plaintiffs' counsel are hot to trot, so to speak. And the first is because the privacy tort is still developing. So the Court of Appeal for Ontario established essentially the tort of intrusion upon seclusion, which is the foundation for a lot of these privacy class actions, particularly for the provinces that don't have a privacy statute. And that they established that in 2012. So even though that's already 7 years ago, our courts are still saying that this tort is still developing. And I've put up a quote from the Tucci case from BC saying that it's a relatively new tort and it should be allowed to develop through full decisions. And that was a certification decision that certified that case. And so you see hesitation on the part of the courts to stop privacy class actions in their tracks at the certification stage because they see this as a developing area of the law. The second theory I have is that because damages in the sense of economic harm or physical harm aren't required to establish a privacy breach and moral damages are available, it really opens up what class counsel need or don't need to do. And so if you have moral damages for quite a large class size, in the case of let's say an external hack that affects all of your customers, suddenly the damages number, even on a moral damages small amount per class member, suddenly they don't have to do much to prove the damages, and they have quite a large amount at the end of the day, because in a lot of these cases, the class sizes are quite large. And so given this, I ask myself, what are the risks? Is there any hope? And what can you do? So it's funny, I prepared this slide before I actually saw the statistics from the Privacy Commissioner, but I think they really track into what the Privacy Commissioner has revealed based on its review of the data breach notifications over the last year. And so the class actions really fall into external hacks. That's what I think most people actually think of when they think of data breaches. They think of a cyber criminal or a foreign government breaching the systems from outside. The second category is vicarious liability, by which I mean essentially rogue employees who are using their authorized access to then misuse that. And as Luca alluded to, that's been a significant area of risk. The third is lost devices, and of course that's employees as well who would be losing their devices or laptops or USB keys, although I separate that out because I think that would be non-rogue employees. That's just people who have lost things. And then use without consent, that's not really a data breach issue, but it certainly falls into the privacy class action category where companies are making use of information in a way that perhaps they don't have consent to do. And then I've just put vendor issues at the end because I think the vendor you've selected can increase risk in all of these areas, particularly depending on the terms of your agreements with them. And Carl will be getting into that a bit more later, but certainly that can underlie these risks. For example, if your vendor is hacked or if your vendor has a rogue employee. And so examples of external actors, I've put 3 up on the screen. They show the various outcomes that can result, but these are all examples of outside hackers, whether they be criminals or foreign governments or suspected to be foreign governments, gaining access to really customer or employee data. And the Kaplan case is a decision that was not certified. And that was really because the information in that case that had been the subject of the hack was disparate. So for some people, it might have just been contact information. For other people, it was everything. And so in dealing with common issues, the court found that it would not be appropriate for a class action. The Lozansky case is an instance of settlement of a class proceeding, and I'll get into those settlement terms later, but in that case, the court really praised the defendant for its conduct in dealing with the breach, and so I think it shows how a company's reaction and how they give notice and whether they provide credit monitoring and the steps they take can influence the court's perspective. And then we've seen Tucci before and the court's comment about letting that decision through, and that's an example where the court certified the class proceeding. So vicarious liability, this essentially deals with rogue actors, and there have been a number of decisions in Canada at the certification stage that have held that a company can, at least for the purpose of certification and whether or not there's a cause of action that's been properly pled, a company can be vicariously liable for a rogue employee taking customer or employee information and selling it or using it for whatever improper purpose it's used it for. The Ari case was an example of a rogue employee selling the information to a criminal organization, although it's not up on the slide, but what the employee actually made in that case for the information was very low, so I thought that was interesting. And I've put up this UK case because that case was actually heard by the UK Supreme Court last week. And it deals with whether or not an employer can be vicariously liable for an employee taking personal information, in that case, of other employees. And in that case, the individual rogue employee went to jail for 8 years or was sentenced to 8 years in jail. And still, the Court of Appeal in the UK found that the defendant would be vicariously liable. And that was a decision on the merits. So in Canada, we haven't yet seen a decision on the merits in the class action world dealing with vicarious liability. It's only been at the certification stage, which I think is an important distinction. So certainly I think, at least as counsel here, I would be looking to what the UK court does, and fingers crossed that they'll give us something useful. Lost devices is obviously another area of risk. We've seen cases of lost devices, and there have been reported decisions as well. And I think all of this emphasizes the importance of employee training and data management policies and making sure that you have the ability, for example, to wipe devices if they go missing so that you can be able to explain to the court that really there's no risk of any harm. And then the last category would be use without consent, where you have consent to obtain the personal information, but then it's used for some other purpose that's then objected to, for example, a marketing initiative. So then, is there any good news? Is there any reason for hope? And I would say yes. I think that the courts are getting used to these class actions and are trying to find ways to prevent the unmeritorious ones from proceeding. For example, the Brutus case, as I mentioned before, concerned only contact information in that case wasn't certified. So it shows that courts are applying some diligence in determining whether or not to allow these cases to proceed. And although we haven't seen any decisions on the merits that will help guide, I guess, plaintiff's counsel in determining whether or not to proceed, certainly we've seen decisions on settlement. And those settlements, I think, have a number of categories that defendants should be thinking about, which is compensation for losses resulting for fraud or identity theft where there's an actual harm that's resulted. The second category would be out-of-pocket expenses, for example, if individuals have had to pay for credit monitoring. Although as part of settlements, typically I would expect that the defendant would be offering to pay for credit monitoring going forward, as well as payment for costs of the notice and administration, as well as payment typically of plaintiff's costs. And the last two categories are not insignificant. I think generally you could expect a few $100,000 for those two collectively, even on a good day. And so then in terms of, is there hope? What can you do? I think that the Lazansky case is a good example of where a defendant's conduct allowed it to achieve a relatively favorable settlement. And I've just outlined the actions that they took in that case, which the court found to be responsible, prompt, generous, and exemplary. And it notified customers almost immediately. It paid for credit monitoring. It had spent several millions of dollars. And then the settlement was in the hundreds of thousands. So what can you do? Well, I would say speak with Carl and Luca. I'm a litigator, so I usually only deal with things once they've gone south. But there's a lot that can be done on the front end to try to minimize risk, including through implementation of policies and training employees on those policies, as well as maintaining records of what you've done in response to the breach and making sure that that's all documented for when you face a class action. And then, of course, segueing into the next topic, having good vendor contracts.
Thanks, Lloyd. So we're going to switch from critical developments to critical issues, namely the role of third-party service providers and their associated risks with respect to data and privacy. Third parties have probably gotten a bad rap as being the weakest link of an organization's data security compliance program. When we assist clients dealing with breaches, it's almost always because one of their service providers has suffered a breach as a result of a malicious actor, an external malicious actor. I think the prevalence of third parties is suffering the breach or being the cause of the breach is likely because organizations often outsource services such as payment processing and web hosting and data hosting, all likely targets for malicious actors, so it pretty much puts them in the crosshairs. So because of that, I thought we'd take a few minutes to sort of answer some issues that we commonly see with respect to third-party service providers by sort of examining these service agreements that you may have in place. And I know you're thinking, like, it's 9 a.m., we're going to spend 10 minutes talking about contractual provisions. You're welcome. But bear with me. It won't be as bad as you think.
I'm listening, Carl.
Thank you. Just need one. So first, a reminder of an organization's obligations under, with respect to third parties. At least those are subject to PIPEDA or the substantially similar provincial statutes. So, of course, organizations are responsible for the personal information under their control, including the information that you're transferring to a third party for processing, your web hosting, your payment processors, your clouds, everything else. PIPEDA requires that an organization use contractual or other means when transferring information to ensure a comparable level of protection. Comparable level of protection means more than just the terms and agreement about safeguarding data. Over the years, and via several reported findings from the OPC, the OPC has taken the position that the service agreements you have in place with third parties must also address issues such as oversight, auditing, and their use of subcontractors. So these service agreements have evolved over time. And now with our mandatory breach reporting requirements, of course, these contracts must also cover obligations with respect to responding to data incidents. Here's a checklist, some of the core terms that are generally included in service agreements with third parties when processing personal information. Of course, this list is going to change depending on your exact relationship and exactly what they're doing with your information. But fundamentally, these are sort of core elements or core provisions we see in service agreements today. Those highlighted in blue are the ones that we'll dig just a little deeper in the next few minutes, particularly identifying common issues that we see and some best practices. Okay, these slides are going to get really ugly, but don't worry, you're going to get them so you can read them on your own time after. And I will not be reading them out loud here, so we're just going to kind of scroll over these and just get some issues and get some best practices out of it. So on the slide, we have two clauses that should be table stakes. On the left, we have compliance with laws, reps and warranties that the vendor will comply with applicable laws, and we recommend getting a bit more detailed, requiring at least three things. Of course, the general clause that they'll comply with applicable laws, that they've developed and implemented a written information security program in accordance with your service agreement and with applicable laws. The OPC will be looking for this. And I've heard them looking for this, so I know it's a live issue. And third, vendor is willing to certify in writing that they have continuous compliance. You can do this upon request. You can do this annually, whatever you prefer. And I'll touch on this point a little later why you actually want to exercise this little right. And then on the right, we have another kind of table stakes, non-negotiable term that hopefully all your agreements have, is basically security of safeguarding the data. So the language in the slide essentially follows the language in PIPEDA, where you're going to require your vendor to establish and maintain administrative, physical, and technological safeguards. Of course, your agreements may be a little more sophisticated, and you may be a little more specific in your agreements, because you may want some of your vendors to actually follow certain data security practices that are in line with your IT requirements or your industry certification requirements. So your agreements might be more specific and fleshed out and say, you will have, you will use encryption, you will physically and logically separate the data from other clients, you will restrict access to authorized users, your physical facilities will be in compliance with industry standards, things like that. So, but I think, what's on the slide is bare minimum, and I would even say is getting to be below industry standard. Another non-negotiable terms with respect to vendor obligations with respect to data instances. Now we have mandatory breach reporting requirements in Alberta and now at the federal level. And we've been finding a lot of clients, not a lot of clients, some clients have been discovering that older vendor agreements do not have these clauses, particularly when these are agreements that have been renewing for 2, 3, or more years and have not been updated to reflect the current mandatory breach reporting requirements. So, again, we're not going to read this, but essentially what you're going to be looking for is to ensure your vendor agreements include the following. One, that the vendor will notify you ideally within 24 hours, but at least as soon as practical of becoming aware of an actual or suspected data breach. As I'll touch on the next slide, you'll want to make sure and make it clear that who the decision maker is with respect to all aspects of a data breach. Defining a data breach, whether you're investigating a data breach, whether you're responding to a data breach. So having that word, either an actual or suspected data breach, moves the clock a little faster, putting pressure on your vendors to tell you that we may have something, we're not sure yet, which is often the case with a lot of complex data breaches. You don't right away always know if you have a data breach that has met the definition under law. So putting that kind of like word there just helps move things along and make sure that your vendors get to you right away so that you can start taking your steps that are required under law. Second, require vendors to fully cooperate with your company as well as your advisors, like lawyers or your forensic experts, with respect to your investigation of the data incident. Third, require the vendor to provide you with the information that you require to meet your obligations under mandatory breach reporting requirements. So essentially, you need them to tell you certain key information, like what information was involved, which of our customers were involved, where do they live, what are their contact details, facts and facts about the investigation, to allow you to determine whether you need to report the breach, to allow you to report the breach, and to allow you to notify affected individuals. And finally, you require your vendor to cooperate with any subsequent investigation that may occur, including requiring them to help you respond to questions if the OPC starts knocking on your door.
And Carl, have you seen any mid-contractual term review of contracts for this purpose, given the change at the end of 2008? Or are you seeing this more just come up at renewals?
Both. I've seen both. I've seen organizations take last year as an opportunity to update their agreements, and others who have used the renewal provisions as an opportunity to update their agreements. I also think the GDPR had a huge effect, requiring a lot of Canadian organizations to having to review and update their Canadian agreements because of the impact of the GDPR. So following the data incident terms, finally, who is the decision maker in this arrangement? Will it be the vendor or the organization? We are encountering more and more issues with respect to who has the obligation to report. In a straightforward services agreement, it will likely be the organization that is responsible for the information that's collected and is subsequently transferred to the vendor. In this case, you'll want to make it clear in your agreements that you're the decision maker and you will decide whether to report a breach or not. So just because the vendor is the entity that suffered the data breach does not necessarily give them the right to decide whether they're going to report a breach of your customer information. This is generally how it's represented under Canadian law. Unfortunately, unlike the GDPR, where we have clear obligations of who is a controller and who is a processor, we don't have that as clearly in Canada. So we're seeing, because as arrangements get a little more complex and as the transfer and processing of data gets a little more global, we're seeing a little more issues arise in Canada because Canadian law is not as clear on who has the obligation to report. So for example, what about when a company A has a partnership arrangement with company B, and the two companies have produced a co-branded product or service? Both companies share ownership in the data, and neither is a service provider to the other. From the individual's perspective or the consumer's perspective, they gave their information to both companies. They gave their information to both companies, and both companies are accountable. We've seen this come up more than once in one form or another, and it can get messy if the language in your partnership agreement is not clear-cut of who has the obligation to report a data breach. And some questions, if you find yourself in one of these sort of arrangements, some questions you're going to have to ask yourself and draft are, if company A suffers the breach, is it only company A that has the decision-making power? What if company A suffered the breach because of something company B did? What if companies cannot agree on whether this particular breach has met the real risk of significant harm test? One wants to report and one doesn't want to report. And if company A's report of breach, if they do decide to report a breach that they've suffered, how will that impact company B from, say, just a public relations perspective? Do you want to have language that they're saying, okay, you can report the breach and you can put up a public announcement, but you're going to keep our name out of it? These questions come up. We've seen a lot of agreements who have really fleshed this out in really great ways, and some who have completely forgot to think about these, and it gets messy when a breach does occur. Another scenario where we're seeing issues is when the service provider suffers a data incident, which affects, say, thousands of individuals spread across hundreds of their clients. In one recent occurrence, the payment processor of hundreds of retail websites in Canada, United States, and Europe suffered a data breach. And so when individuals finalize their purchase on their client websites, they accepted the privacy policies of the clients. They thought they were giving their payment information to the clients. Everything from their perspective seemed like I was giving my information to one of these online retailers. But in reality, the payment processor was collecting the payment on the back end. The payment information never went to any of these hundreds of online retail websites. The consumer is not directed to, and when they were finalizing their payment process, they were not directed to a pop-up window or another website that said, okay, you're leaving this online retailer and you're now going to finalize your payment on a separate entity. From their experience, it was just a smooth experience that my data was going, including my payment data, was going to these online retailers. The processor took the position that they were going to report the breach to all the regulators in the respective jurisdictions, including Canada. Some of these retailers objected to this position. They were basically concerned that if you, payment processor, reports the breach, I am not meeting my obligations under PIPEDA to report a data breach of my customers. The agreements between the payment processor and all the hundreds and hundreds of retailers were silent on who had responsibility to report to the breach. Eventually, the payment processor, we took the position that the retail websites took the position that the payment processor should report the breach to the regulators because they collected the information directly from the customers. And if you scrutinize PIPEDA enough, we thought we could hang our hat on that. Even though from the consumer's perspective, they thought they were giving their data to the retailers, but in reality, the retailers never touched it. And so we're going to hang our hat on the fact that we have established a direct relationship of collection coming directly from individual customers, and that it was our responsibility, our obligation to report the breaches. We also took steps to notify the Canadian retailers and get their consent. We used very careful language in a report to the OPC saying that we collected the data directly from the customers. So that kind of made it clear that we are the ones who have a direct relationship, therefore we have the ones who have the obligation. And we also took some other additional steps, which I won't get into, but it's a good case study to really think about how are you drafting the agreements with your service providers. Let's quickly switch gears to just a few provisions that we often see pushback, improvements. I'm going to skip this one for time, and it's not that interesting. So another important provision that often gets pushed back is the audit rights, and I really wanted to hit on this. So on the left, we have our starting point, that is often the company has the right to visit and inspect and audit your vendors, inspect your locations and where they process the data. And basically, it usually includes three things. One is you require the vendor to make their policies and procedures available upon request. You make your vendor provide representatives or employees available as part of your inspection, and of course, they will otherwise assist with your auditing of their premises or their services. Vendors often object to this because they don't want all their clients coming to their premises and auditing them, and of course, companies don't have time to do this anyway. But an alternative or a fallback that you should consider is at least thinking about if your vendors are going to do their own independent audits anyway, put the language in there that you are allowed to have a certificate of an audit, or you get a copy of the annual report. If that satisfies your IT personnel, your InfoSec personnel, then put that in there. Or also, if they are certified with, say, PCDISS or some other kind of like industry standard, then put some language in there saying that every year you'll provide us with an updated certificate of compliance. And I encourage you, if that is going to be your fallback, then put that in your calendar every year. Request them from all your vendors every year. They just come by mail or email. Store them, log them, and build your due diligence. If worst case scenario, the OPC is ever on your door and says you have not been monitoring your vendors, you can say, well, at least I've been doing this. That's it.
I think we can
Skip?
skip.
Okay. So to that point, we have many comments and through investigations or publicly on announcements from the OPC saying that just entering an agreement and then coasting is insufficient. They expect organizations to go a little further on their vendors and do some audits, do some monitoring, make sure they're still in compliance. Which I guess the lesson is either review your vendor management program, or if you don't have one, take the opportunity to create one. Establish some policies. Make sure that your marketing team will not run and sign up the cool new vendor from Waterloo without letting you know before your data goes in some gets used in some kind of crazy way. Then the OPC is going to be knocking on your door. Vetting your vendors, impact assessments, consider audit rights. And then we have 1 minute about privilege.
And questions. So I'll just be very brief. Obviously, protecting privilege, particularly over expert reports that you might obtain following a breach, is very important. And the Privacy Commissioner, based on 2 Supreme Court of Canada cases, doesn't have the right to obtain solicitor-client privileged documents, and so making sure that you're protecting that and not freely giving that up is very important, because the privacy legislation federally and in Alberta, which are the 2 pieces of legislation that have been considered, don't have the explicit language that would be needed to allow the Privacy Commissioner to gain access to that. As well, you can expect that plaintiffs' counsel or the media or privacy activists will do an access to information request and try to gain access to the Privacy Commissioner's files. And so making sure you're not waiving privilege in that way is very important. That's another reason why making sure that what you provide to the Privacy Commissioner is accurate is very important, because as I've seen, you can get that back in a motion record. So that's very important. I think that really covers it for now. We don't really have any time left, but we are we're here and happy to answer questions. And I think there is a bit of time before the next session. So I don't know if we want to go briefly to questions either in the room or online.